Hey, good morning, everybody. Welcome back to Law and Legitimacy. And I think today, Deep State's going to have a little more trouble knocking us off the line. No, I haven't fallen down a rabbit hole, and I'm not now a full-time conspiracy theorist. But it sure made me wonder yesterday, the day I wanted to talk about the Justice Department's war on the First Amendment and why Merrick Garland was the Jean Valjean of American politics. It would be that day that we would have connectivity issues and have to abort our broadcast early. So we've now switched, or I've now switched to a desktop rather than a laptop. I've got DSL connection, and you're going to have to try harder, Uncle Scam, to shut us up today, because we ain't going to be shut up. So thanks for coming back, and we're going to take it from the top yesterday. We're going to pretend yesterday never happened and talk about the Owen Shroyer case. And I thought what I'd do is lay down a factual baseline of indisputable, undisputed elements of his prosecution. Things that, and what do I mean by that? Because everything can be disputed these days, correct? I mean, didn't Rene Descartes say with systematic doubt he could doubt everything other than the fact that he was thinking, and hence we get the famous cogito ergo sum. I think therefore I am, and that's where certainty began. Let's forget about that. We live in a world of common sense. Here's what happened. Owen Shroyer works for Alex Jones. He works on Infowars. He's the afternoon personality. He has his own show called The War Room. Alex goes on in the morning. Owen goes on in the afternoon. Or actually, Alex goes on midday. The morning show is anchored by a young man named Harrison Smith. And then Owen does the evening. Owen was covering the Nadler impeachment hearings. Nadler was, at the time, and maybe still is, chairman of the House Judiciary Committee. They were holding hearings on Donald Trump and his impeachment. And Owen went to one of the hearings in I believe it was late in 2018. I don't recall the date. And he disrupted the hearing. He marched to the front and talked about Nadler needing to be impeached. Now, the First Amendment says that Congress shall make no law regulate, infringing freedom of speech, but we do have those laws. And one of them is in a public forum, there can be a reasonable time, place, and manner restriction on speech. And so it can be, a public entity can insist that you sign up and that you speak in turn, and they can place time limits on your speech. And the reason for that is to avoid a public meeting becoming a cacophony and permit the public's work to be done. So Owen approached the proceeding, disrupted it, was arrested, and held overnight in a jail cell and presented to a magistrate judge the next day, and charged with interfering with Congress, a misdemeanor. We got him released. And in the end, we negotiated a resolution of that criminal case in 2019, before the election. And we may have got to the resolution in 2020. Again, I should have looked at the file before we got on the air. But the point is, well before January 6th, Owen had resolved the disruption of Congress case as to Nadler. And the government agreed to let him into something called a deferred prosecution agreement. A deferred prosecution agreement is what lawyers will call a diversionary program. It permits a person to satisfy certain conditions that the government imposes. And if the person satisfies those conditions, the government will then dismiss the charges. And although the person has been arrested, the dismissal will result in his having no criminal record. And what's more, because the charges have been dismissed, you can truthfully answer that you've not been arrested, even though it's counterfactual. As a matter of law, an erased file is a file that doesn't exist. So Owen enters the DPA. And one of the conditions of the DPA is, well, there are two primary conditions that become central to the service. And the second is that he not go on Capitol grounds with the intent to harass, annoy, or delay, or otherwise disturb congressmen or congressional proceedings. And that is in the bank. 2020 evolves. It was a COVID-topic kind of year. Owen had some difficulty finding a place that would permit him to come and do community service, but he ultimately found one. The election takes place in November of 2020, And Infowars, Alex, Owen, and many other people believe the election had been stolen. They believe that the election was typified by corruption, and they believe that Biden is an illegitimate president. Millions.
Hey, Norm, do you mind if we just, I guess, review the terms of that deferred prosecution agreement, which I've got on the screen here, because I do think that some of that's going to become relevant later. And instead of running back to this, but you spoke about the 32 hours of community service. Of course, that there was an issue there, and we'll talk more about that. You've already made a reference to that, but especially with the way that the DOJ treated the reporting of that 32 hours of completed community service to the court. But in respect to the deferred prosecution agreement, that required that Owen, and it's right here, but he stay away from what's quote unquote called the Capitol buildings, and they define the Capitol buildings in this to mean the United States Capitol, the Senate and House office buildings and garages, the Capitol power plant, all subways, enclosed passages connecting two or more of such structures, and the real property underlying and enclosed by any such structure. And he wasn't allowed to do what's known as utter loud, threatening, or abusive language, or to engage in any disorderly or disruptive conduct, and with the intent to impede, disrupt, or disturb the orderly conduct of any session of the Congress. And he also agreed not to parade or demonstrate or to picket within that area that I just described, the Capitol buildings. So in terms of the way that I'm supposed to read this deferred prosecution agreement, Norm, one thing that we didn't get to even really get at yesterday, and I'm glad we're resetting today, is what is meant by with the intent to impede. And I'm coming at this, let's say I'm a first-year law student and I'm just now getting into torts. We'll call it civil torts. I know criminal torts are a bit different, but in general, trespass doesn't always require a mens rea or an intent element to trespass, right? The act of being in a place that you are otherwise not allowed to be is in and of itself the trespass, no?
Yes, that's what trespass is. You're in an area that you're not supposed to be in. Now, in Owens,
knowing is the issue, right? My understanding has always been that knowing is not necessarily even relevant for purposes of saying that you have trespassed. Now, there are always trespassing signs on real property and stuff like that, but this is really interesting to me, just from a perspective of the outlining of with intent to impede, disrupt, or disturb the orderly conduct of any session of the Congress, right? And so that becomes relevant for January 6th. I just wanted to highlight that as part of this. Hey, you're not allowed to be here doing any of these things with this specific intent. Does this mean that he could have gone to the Capitol in the normal course of business to be a tourist on another day of the week when all of that stuff is open to go and see any of the other stuff around there where there are guided tours with the general public?
Yes, and that was a specifically bargained for piece of concession, because they initially wanted Owen banned from the Capitol grounds, period. And we took the position you can't do that. First of all, he makes a living as a journalist. And the judge was skeptical of the government's right and ability and power to do that. So we negotiated something that would permit him to cover the Capitol as a journalist, to be present on Capitol grounds, so long as he didn't intend to impede, disrupt, or disturb the orderly conduct of a session of Congress, or otherwise engage in loud, threatening, or abusive language, or parade, demonstrate, or picket within any of the Capitol grounds. Those are not activities that a journalist customarily does. Sure. And so this DPA was in place on January 6th. January 6th comes, and Owen and a team from Infowars, including Alex Jones, who's referred to in Owen's arrest documents as to January 6th as person one, were in the United States Capitol on January 6th. They attended President Trump's speech at the Ellipse, and Alex helped organize the event. And they had a permit to speak in an area near the Capitol, so-called Section 8. They left the area of the Ellipse amid some confusion and headed toward the Capitol. When they arrived at the Capitol, all hell was breaking loose. And Owen and his team went past the Peace Circle area where the Proud Boys and others first breached Capitol grounds, as it were. And they proceeded on toward the Capitol, where at the East Steps they saw officers, security officers who had formed a perimeter around the Capitol. And one of Alex's security people asked the officers if Alex could go on to the steps to try to calm the crowd down, to try to get them to stop doing what they were doing. Ultimately, the guards acquiesced. Alex went onto the steps with his bullhorn, Owen standing next to him, and Alex urged people to go elsewhere and not to give the left, as Alex put it, what they wanted. That is disruption and the ability to transform this event into a propaganda bonanza, which is precisely what's happened. So they leave the grounds. None of that group. Owen never enters the Capitol. And the next day, the Wall Street Journal runs a piece saying that Alex Jones was on the steps of the Capitol, inciting the crowd on, urging the crowd on. We called the Journal and demanded a correction. I spoke to one of the reporters, Ted Mann, whom I have known for quite some time since he had previously reported in Connecticut. And I said, "What up? I mean, we've got video footage." I'd seen video footage that was taken by Alex's team of him asking the crowd not trying to ramp the crowd up, but trying to calm the crowd down and direct it. Mann and said he and a colleague were standing right there. They thought they heard Alex inciting people. I said, "You heard wrong." And this is a perfect example of confirmation bias and why the media needs to be challenged rather than blindly accepted. I provided the Wall Street Journal with the videos of Alex, and they did what they don't often do. They printed a correction the next day. So, fast forward now into early February, Owen presents us with a list of the community service he's done. It's now February 5th. We write a email to the prosecution saying Owen has completed his community service. We're asking for dismissal of the DPA pursuant to our agreement. The prosecution writes back and says, no, he's under investigation for January 6th. And what's more, he's supposed to do 32 hours. He only did 30. We double checked the math. Oh, you're right. He needed 2 more hours. So he went out and did 2 more hours, and those were completed by March. We filed a motion.
And just to emphasize again, doing community service during an era when the entire country is being shuttered and told to not be with one another, crowds are not allowed to gather, these sorts of things, with certain exceptions. We'll put an asterisk next to those that need not be named. But that becomes a real issue. I didn't even consider that part of it until you brought this up, Norm, in terms of the chronology of events here, is that he's, obligated to complete 32 hours of community service during arguably the toughest time to even volunteer one time.
Well, unless you're volunteering to burn a building down.
Right.
Okay. In which case, BLM, and maybe Kamala Harris will underwrite travel expenses and pay for your bond if you are unfortunate enough to be arrested. But in any case, so the prosecution writes back and says, we ain't doing it. So we file a motion saying that they're breaching the agreement, and they're doing so in retaliation for Owen engaging in protected speech on January 6th. The court never hears that motion. It gets calendared, and the case gets continued for one reason or another. And then in the summer of 2021, federal prosecutors call and say they've got a warrant for Mr. Shroyer's arrest. He needs to turn himself in. Now, they happened to catch me on my way to one of my kids' weddings. So I'm like, we're not doing it this weekend. So we reconvene, and the following week, Owen turns himself in a Texas courtroom. The case is transferred to D.C. He waives a grand jury indictment. In other words, I look at the warrant affidavit and I say, you don't need to do an indictment. We'll deal with this case. And then the prosecutors immediately ask me if Owen would relinquish his phone. They need to get a warrant for his phone.
That's really interesting. So back just one second there. So can we talk about the impact of waiving the grand jury indictment?
Well, so under the United States Constitution, you have the right to be indicted by a grand jury when you're charged with a serious offense. And sometimes prosecutors will proceed by way of a criminal complaint. They'll put before a judge an affidavit that summarizes their reasons to believe you violated the law and asked for your arrest. Usually that means there are exigent circumstances or there's some reason to avoid the grand jury process. A defendant can say, wait a minute, this is just. I want a grand jury. And, you know, judges wink at prosecutors and they play footsie with the Constitution here. They sign criminal complaints avoiding the grand jury process at the request of prosecutors, almost without regard to the law. So we were not looking to pick fights that we didn't think we could win. And so with respect to the summary of reasons to believe that Owen violated the law, I believe that if that summary were placed in the form of evidence before a grand jury, the grand jury would indict. So
your experience and expertise here basically, I guess, materializes on Owen's behalf as saying, let's not waste time. Let's push forward. This is almost
try to resolve the case.
This is a near certainty that the indictment would come anyway. Let's not waste time.
Yeah, exactly. And, you know, and this is not a serious case at this point. So in my view, so the government has me on the phone. I'm traveling up to the wedding, and they asked me if you know, we would relinquish his phones without a warrant. I said I'm not going to agree to anything until I read the affidavit justifying his arrest. I read it and I'm like, seriously, they're doing this? You know, and so I called them back and I said, I don't know what we're going to do about that. I mean, I'm not even sure you've really alleged much of a crime. And so let us think about it. We all got distracted because I don't think at this point in August of 2021, anybody really thought that the federal government was going to try to arrest each and every person that was anywhere near the building. They've now gathered probably close to 300 terabytes of information in their efforts to identify every soul that was on Capitol grounds so that they can arrest them within the 5-year statute of limitations. So the government gets distracted. They call me back at some point and they say, we want to resume the discussion about the phones. I say, well, you know, and I say, well, why would we do that? Well, this will go a long way toward our sentencing recommendation. I said, I'd like to walk Owen. Are you open to that? Yeah, we're open to that. We're not going to be jumping up and down, they say. Now, in retrospect, I should have got that in writing. I got it verbally from one set of prosecutors who were ultimately replaced by others. We give them the phone.
Always a great thing, right?
We give the phone to the feds, and it takes them months to download them and examine them. They call up. They say, we've completed our examination of the phone. We'd like to talk to Owen. So Owen agrees to waive his right to remain silent, his Fifth Amendment right to remain silent, and to participate in something called a proffer. Now, for you Scrabble addicts, that's PROFFER. And in a proffer, a person waives the right to remain silent. And in exchange, the government agrees not to use the words that this person says in giving that statement against him. They can use investigative leads, that they find and that he gives them. It's a gamble. But we were operating in good faith at that point. Owen's got nothing to hide. He appeared on Capitol grounds as a journalist. He didn't have the intent to impede the proceedings. He was with other protesters trying to get Mike Pence's attention because they believed, Pence disagrees, but they believed he had the ability to behave otherwise that day and to stop the proceedings because they believed there was election fraud. And by the way, folks, you know, those of you who think that January 6th was a coup and treasonous and all that other jazz, what can you imagine one thing worse than what the folks did on January 6th? Because I can. That would be if an election were actually stolen and the will of the people subverted. And on that day and in the months prior to it, the president of the United States was making that assertion publicly. And if people chose to believe the candidate they elected, I don't think that makes them criminals. But in any case, Owen gives the proffer, and, you know, in a proffer agreement, you can be prosecuted for lying to the feds. It's a crime if you lie to federal officials. It's not a crime if they lie to you, by the way. That's an acceptable law enforcement technique. That issue's been all the way before the United States Supreme Court. But in any case, no one ever suggests that Owen lies. It goes very well. The proffer does, and it's not very long. We only sat with them for about 2 hours. I expected the proffer would go for a day or even more because of the questions that the House committee, the January 6th committee, tried to ask Alex Jones. I represented Alex in the House investigation, and they were desperate to prove a linkage between Jones and the White House and the events on the ground on January 6th, because the operating theory was that this was a seditious conspiracy, if not initiated by, then aided, abetted, and encouraged by Donald Trump. and they wanted to get Alex Jones, or they wanted to get the Infowars network into that loop to see what, to see whether Jones and others were directed by the White House. There was no proof of that. There is no proof of that. That did not happen, and none of the charges that have thus far been brought has made that assertion. So we give the proffer. We don't hear anything back, and Judge Kelly, who sentenced Owen, was the same judge who tried the Proud Boys case. So for 5 months, we were all busy with something else. That trial ends. Owen enters a guilty plea to 1 count of trespass, and sentencing is set. Sentencing took place last Tuesday, I guess it's this week. It only feels like last week now. And in the government files a sentencing memo, and I call them. They send me a private note. We're going to be sending the judge the following videos. And I call him up. I said, why are you sending him videos? This is an agreed plea. You guys aren't looking for time. Oh, we didn't say that. I said, well, in fact, you did. And they said, well, we don't recall any such thing. And I'm like, okay, that's how it's going to play. That's how it's going to play. So they file a sentencing memo, and in it, and this is where it gets very interesting, and this is where I'm going to be somewhat polemical. Everything I've told you thus far is about as uncontroversial as the fact that there are 26 letters in the alphabet. They file a sentencing memo, and in it they say that Owen's one of the people who is responsible for January 6th, that he engaged in distributing disinformation, that prior to the breach of the Capitol, he was chanting 1776, death to tyrants, that afterwards he showed no remorse, that he continues to believe the election was stolen. He continues to believe disinformation. And my response to all of that is, so what? I mean, he could believe that Joe Biden is a potted plant watered by communist Chinese water pills every day and assert that to his heart's content. That's free speech. He could have appeared at the Capitol that day and screamed anything he liked. That's free speech. He could have peacefully assembled for the redress at the Capitol. That's freedom of assembly. He could have petitioned for the redress of grievance. That's the redress of grievance clause in the First Amendment. These are core constitutional values. So that I filed a counter motion, just basically asserting that this was asserting in fact that this was a low watermark for the Justice Department in its prosecution of J6 defendants, because they were seeking to enhance a sentence for Owen based on his speech. Now, under federal sentencing guidelines, every federal offense is given a point value. And also in the government sentencing memo, they just asserted something that's just not true, that Owen hadn't completed his community service. And, I see a lot of wise guys online. Owen didn't complete his community service. They did. Listen up, assholes. If you're going to make assertions of fact, do your research. Go to the docket sheet. We'll look at look at what was filed, and you'll see proof that even Judge Kelly accepted that Owen completed his community service. So can we move on from that, please? We get to the sentencing hearing, and Judge Kelly is now faced with a problem similar to what he faced in the Proud Boys case. In the Proud Boys case, we took the position that all of the incendiary rhetoric that the Proud Boys engaged in before, after, and during the march on the Capitol was protected speech. Under United States Supreme Court precedent, praising illegal acts is lawful. Mere abstract calls for violence is lawful. Calls for violence at some future date is lawful. Yes. You don't believe me? Read the Brandenburg decision. Read United States versus Noto. Read United States versus Watts. There's a line of cases. They're not a block long, maybe a house or two long in a congested urban neighborhood, but there's no dispute about these factors. None. And so I say to Judge Kelly, the government in the Proud Boys case is trying to take speech that there's nothing the Proud Boys ever said that they could have been prosecuted for. It's what they did that got them prosecuted. And the government, and what they did was they breached the Capitol. And so the government used their speech to prove intent at the moment of breach. Their intent at the moment of breach was to use force against the United States government. That's seditious conspiracy. But even their the prosecutor who argued their case at the end, Connor Mulrow, argued that this was an implicit conspiracy. There was no plan. And that implicit conspiracy could have been formed instantaneously, even after the first breach. So, all of you out there who are saying the Proud Boys planned this, even the government acknowledged that didn't happen. There are two cooperating witnesses. One of their cooperating witnesses, Jeremy Bertino, said there was an understanding, but he could point to no plan. One of the government witnesses who served in the military in Afghanistan and had seen food riots emerge said that what happened that day at the Capitol felt like a food riot. When you pass out a candy bar and 15 people come after you because they're starving and they want one too. The people at January 6th at the Capitol were starving for what they thought was justice. They thought an election had been stolen. They thought Mike Pence had the power to stop the steal, and they erupted, and it was violent, and a lot of it was unlawful, and misdemeanors and some felonies were convicted. But seditious conspiracy, give me a break. In any case, in Owen's case, so in the Proud Boys case, Judge Kelly ruled that their speech, the Proud Boys' speech, the incendiary protected speech, could be used to prove intent. In Owen's case, there was no such argument because he merely had trespassed. And he had merely trespassed, and there was no need to prove intent.
Which is why this is exactly why I wanted you to talk about the intent element in relationship to just the concept of trespass generally at the beginning of this, because being in a location doing a certain thing that is unlawful by the existence of your presence there does not require that you intend at all to be in a place unlawfully. You just are. It's sort of almost a strict liability sort of perspective, right? You don't have to intend to be speeding to get a speeding ticket. You just were speeding, right?
So the government took the position that Owen's speech that day and before and after was what's called quote unquote relevant offense conduct. And relevant offense conduct is something that a court can consider in imposing sentencing. And we took the position that protected speech that was valid and that had enjoyed constitutional protection could not be considered as relevant offense conduct. Otherwise, you would be punishing speech. And so we went round and round the mulberry bush on that. In imposing sentence, Judge Kelly did refer to Owen's speech a couple of times. And so we will be taking an appeal of that. And I'll say more of that in a moment. So the government sought 120 days, arguing that an example needed to be made of Owen so that this would never happen again. And they argued that his spread of disinformation about the stolen election, in their view, his chanting of 1776, his chanting death to tyrants riled up the crowd and therefore was in part responsible for the mayhem of January 6th, and general deterrence, that is, the need to deter others, required that he go behind bars. I argued otherwise. I argued that he'd had 2 years of successful pretrial supervision, effectively in custody of the Department of Probation, who put conditions on his liberty, that he had completed his community service. There was no serious dispute about that, and that his conduct amounted to a mere trespassery offense. The court held that he was a recidivist, that he was a repeat offender, that because of what he did with respect to Nadler in disrupting Congress and what he did on January 6th, appearing on a prohibited grounds, on the Capitol grounds, he had earned himself some time behind bars. The pretrial services officer, the person who prepared a draft pre-sentence report for the judge, recommended 0 time for Owen. His guidelines for sentencing range was 0 to 6 months. The government asked for 120 days. We asked for 0, and the judge split the baby. This is what Judge Kelly has done in most cases that he has sentenced in on J6. In the Biggs case, for example, the government asked for about 10 years, or not the government, the pretrial services officer asked for 10 years. The government asked for 32. The judge gave 17. In the Zachary Rell case, the pretrial services officer asked for about 10 years. The government asked for 30. The judge gave 15. I call this the problem of the unscrupulous merchant. Suppose you want to buy a hammer, a nice hammer, a sophisticated hammer, and that thing has a market value of $10. But the guy at your hardware store who owns it marks the price up to 30 because he wants some money. He's unscrupulous. He wants too much money. But he decides nobody will pay 30 for this. So he says, we're marking this down to 15. Are you supposed to thank them for paying half the marked up price when the marked up price is still too much? And so the government has always asked for too much in the J6 cases. And in almost no case has the government gotten what it's wanted. In almost every case, judges have undercut the government, but the government keeps coming back. Like that, what's the definition of insanity? Doing the same stupid thing over and over and over and again, but expecting a different result every time. In this case, it's calculated dishonesty by the Justice Department. They have declared a jihad on dissent, and they, in their effort to try to inspire people never to appear at the Capitol again and engage in similar behavior, they're sending a chilling message by sentences that are draconian.
Well, and admittedly, they don't have an incentive not to. I don't want to sound like I'm taking up for the Justice Department here, but as I guess regrettable as their behavior is to continue asking for far more in sentencing than they should be. What incentive do they have to stop that when the judge is consistently giving them the same treatment? Right? There's there's absolutely no learning model there for them to structure a different sentencing ask.
The courts in the J6 cases have abdicated their responsibility to be a check on the government. They've become a branch of the government. And then you'll say, well, of course they are. It's the judicial branch. But the judicial branch is there to apply the Bill of Rights and to serve as a barrier between the people and its government, and to make sure that people aren't abused by government. When the courts themselves become an instrument of abuse, that undermines respect for the institution. And candidly, I've lost an enormous amount of respect for the courts based on what I've seen in the J6 cases. Laws were broken. The Proud Boys would have pled guilty to lesser offenses than seditious conspiracy, but the government wanted seditious conspiracy, and the government wanted these guys to make examples of them. We went to trial and lost. Prior to that trial, we lost with a DC jury. There were change of venue motions argued, and those may or may not be taken up on appeal. In Owen's case, he tried to negotiate in good faith with the government, and he cooperated with the government. He gave the government what it asked of him, but because the government didn't get what it wanted from him, that is proof that the White House directed this and used Alex Jones and Infowars as a means of doing so, I think they turned on Owen, and they got drunk and intoxicated on their own power and the power the judges have given them to get more than justice requires in each of these cases. I remind you, the pretrial services recommendations of guidelines in each of these defendants, these are never made public. They're filed under seal. But every single one that I have seen in these cases has been ignored by the judges. And the judges have given an inflated sentence, less than the Justice Department asked for, but more than the professionals thought was necessary. And they did so because the judges have become willingly complicit in the unscrupulous merchant problem.
We've got some, and I want to just highlight that a little bit more here. I don't want to say better, but I think Lawyer Will and Jackson Barrett, we'll get to your question about the perhaps other incident that led to the recidivism conclusion. But Lawyer Will says it's like stores that advertise big discounts off a retail price when the store never charges the full retail price. I'm sure we all know some chains that absolutely do that, but that is in and of itself, I guess, an example of the basis for the concept of the unscrupulous merchant, holding out to a potential consumer that they are saving money by purchasing at the price listed by artificially inflating the price to something that they would absolutely never pay. I think that the same goes for this. I'm going to find a way to relate this to alcohol law because I have to out of obligation. But what a lot of people don't know in grocery stores, every chain grocery store has some sort of like discount or loyalty program card or something that you scan when you go up before they start scanning your items, so that you get some sort of in-store discounts on all the stuff from the shelves as listed. But the one thing in North Carolina, at least, that does not apply to is alcohol. Why? Because there is a happy hour ban in North Carolina, whereby anyone selling alcohol at a discount must afford that discount to every single consumer for every hour of the day that they are open. Meaning that if you go in North Carolina to any store and you go to the wine section or the beer section and there's some sort of discount on a product listed, that is the unscrupulous merchant problem in action. To be fair, they should just be advertising the sale price because everybody is entitled to that price, not just members of that store with the loyalty program. here, and I want to get back to what Jackson Barrett you were saying. Yes, here the problem is because this is a chilling effect, but it's based on false narratives. And Norm, here's a question for you. Jackson asks, Owen had a second run-in with Capitol Hill police prior to J6 when he protested with tape over his mouth in the Capitol gallery. Yes? And before you answer that, my assumption is that that was not listed or used in any of the justification for the sentencing, but I could be wrong.
Yes, he did. And no, he was not. That was not part of what the government argued.
Okay, got it. And then Lawyer Will says you could charge someone for being a Republican in D.C. and a jury would convict. I don't think.
Yeah, I mean, I have very little confidence in D.C. juries. I mean, I think I've told regular listeners who've heard me say this before. Normally in federal court, it takes a day or less to pick a jury. In a controversial case, it could take a couple days. It took 12 days in the Proud Boys case because the one of the narratives, the Proud Boys, to the degree that there was violence in the run-up to J6, it was violence between the Proud Boys and Antifa. And so Antifa was front and center in this trial because it was the Proud Boys' justification for reorganizing and appearing armed with vests and whatnot. There'd been a stabbing in December, and the Proud Boys were concerned about it. And they organized to defend themselves. And and one of the things I learned, and one of the reasons I was so happy to have this case, is I wanted to know more about why people turned up at the Capitol. Why people were as upset as they were. And what I learned is almost all the people that I interviewed were outraged by what happened in the country in the summer of 2020. They felt their country was being stolen from them. They were told to stay home, shelter in place, don't work, take your PPP money, shut up, sit down and stay home, unless you wanted to go to your neighborhood grocery store and burn it down for George Floyd. And they felt that somehow the government had broken faith with them. There were no prosecutions for arsons. There were no efforts to clear the streets. And then suddenly we were warned before the election, because of COVID, there are going to be a lot of absentee ballots. People can go downtown and engage in arson and overturn a police car, but they can't go to a polling place. What are you trying to do with these absentee ballots? They had reasons to be suspicious, and Donald Trump fed those reasons. And so they were angry for political reasons. And we have a right to appear at the Capitol and to petition for redress of grievance. You don't have a right to enter the building when the police say don't. Okay, charge a person with trespass for that. You don't have a right to clock a cop unless it's in self-defense. And if there's evidence that somebody did that, charge them with the felony. But this business of seditious conspiracy and, the republic was in jeopardy is a bunch of bullshit. And I mean, I'm sorry if you've got children listening. I hope there's a delay. That's cow feces.
My favorite phrase of the week, I'm just going to bring it here live, is silly bullshit. It's
silly bullshit. I mean, the evidence at trial was unambiguous. The Capitol had prepared for contested hearings, the Capitol Police, the Secret Service, everyone involved. There were witnesses from each of these entities. They knew that though the hearings involving certification of the election could take 2 or 3 days. And so they had staggered police rotations where the full force was not present the first day of proceedings because they wanted to cover the building 24 hours a day for 2 or 3 days. There was a riot. It was scary. Some people got hurt. Ashley Babbitt was shot and killed. Some officers, committed suicide thereafter because they were stressed out. Whether they were stressed out because of the crowd or whether they were stressed out because they were mismanaged and set to do a job that they didn't have the tools to perform.
Well, and here's what's even worse. Well, not even worse than what we're seeing with the treatment. But one thing that doesn't go discussed enough, in my opinion, is recall that after all this happens and in advance of Biden's inauguration, the entire Capitol was militarized in a way that I have never in my life seen. And it was to a degree as though it was as if it was a move so that the public consciousness would be moved to believe things that never existed about January 6th, to otherwise validate the transfer of power, right, in the faces of those who had legitimate questions to which you just referenced, right?
Oh, that's true. So, so it was an overreaction. So with, I see we're over time. I want to try to wrap up the Owen discussion so we can move on to other things this week. So we're going to take an appeal in Owen's case, and it's going to be difficult. We're going to be filing a motion this week to keep Owen out of prison pending the appeal. We have to show a substantial likelihood of success. in order to get the judge to grant that. Judge Kelly suggested he has reasons to doubt we can do that. And one of those reasons is when you enter a plea in federal court, the plea agreement basically says you're not going to take an appeal unless your sentence goes above a certain range or the sentence was otherwise unlawfully imposed. This sentence was within the guidelines ranges, and so therefore we can't appeal that. We're not going to try to appeal to take the guilty plea back. I've seen that reported as well. But what we are going to appeal is the fact that the government asked for and the judge relied upon Owen's protected speech at a time where he was present on Capitol grounds as a journalist to prosecute him. The Shroyer case is a shocking precedent because we have a man operating as a journalist on the Capitol who was penalized for what he said. He wasn't arrested for what he said. He was arrested for trespass, but he was penalized for what he said. And the United States Supreme Court simply has to do something about that. I expect the D.C. Circuit Court of Appeals will wink at it and say, oh, well, not in our house. And I'm hoping the United States Supreme Court will hear this case. So if you are inclined to assist Owen, he's set up a Give, Send, Go page. And it's the Owen, I think it's the Owen or the Shroyer Defense Fund. I'm not sure what it's called, Mike. I don't know if you can find it.
Yep, I've got it right here.
He's asking for symbolically, he's asking for $177,600. That's a tidy sum. In the first 24 hours of the page's existence, he's raised nearly $40,000. If you're inclined to want to contribute to it, go ahead. And yeah, I do benefit by that. So yeah, this is, I guess, my trying to line my own pockets. But freedom isn't free. And if you want a legal fight, you can, the government doesn't work for nothing. It gets paid, and neither should defense lawyers. So we're in this to win it. It's an important fight. Even if you don't contribute to Shroyer, check them out on Infowars. But pay attention to this case and pay attention to what the government's doing in the January 6 cases. I'll end on this note. I said in a press conference after the case, I used to feel bad for Merrick Garland.
And I have this on the screen as well. So for those of you who have seen what I have on the screen for the last, half hour or so, this is the page you can go to on Infowars, and you can hear and watch Norm give his post-sentencing press conference here. Sorry, Norm.
But I said something in the press conference I regret, but since it's out there, I'll repeat it here. I used to feel bad for Merrick Garland. I thought he got shafted by not having his nomination to the Supreme Court acted upon by the Senate in the waning days of the Obama administration. But now I don't think he's fit for the Supreme Court, and I certainly don't think he's fit for the Justice Department. Prosecutors have the ability to pick and choose who and when to prosecute. They also have a responsibility to do justice. In this case, the Justice Department is making January 4th into a signature event, an event as significant, I would suspect, over time as Waco was in 1993. What am I talking about there? In 1993, federal agents had a warrant to search the Branch Davidian compound in Waco, Texas, because of firearms violations, suspected firearms violations. There were also suspicions about abuse of children, sex with minors, and so forth. There was a standoff. Did anybody watching that standoff expect it to end with the building being burned to the ground and 80 plus people dying as a result of that fire, a fire caused by the federal government? A fire in which children were incinerated? People were outraged, and public opinion polls began to show a lack of confidence in the United States government thereafter. I suggest that the government's doubling down on January 6th is a profoundly delegitimizing event. 3 years after the Civil War, most all the rebels had been repatriated. That's a war in which 600,000 Americans lost their lives in hand-to-hand and violent conflict. In this case, we're prosecuting trespassers and sending them to prison almost 3 years after the event. To what end? Merrick Garland, you are the Jean Valjean, the twisted prosecutor of American politics. The figure is from Victor Hugo. Stop it already.
We will be back tomorrow morning at 8 a.m. live on X at LawPod Daily. We're also live on Rumble, where most of our comments come from. We are most active over there, but that is not to slouch or slight the YouTube chat. We appreciate everybody in the YouTube chat as well. And if you're on YouTube, those are the ones that you can often see here on the screen. We have someone from India this morning by the name of My Lord, and my lord was
Lord.
he or she was asking what type of cases we take up for discussion. I just provided that any that provide a lens to institutional authority, governance, and legitimacy. And my lord was curious enough to know whether we're both practicing lawyers, whether we're independent or colleagues of the same firm. So I think this is great because we don't often talk about this, Norm. We are both practicing attorneys. Norm is based out of Connecticut. I'm based out of North Carolina. We are from two completely different firms in two different states, and more importantly, from two entirely different practice areas. My day-to-day looks extraordinarily different from Norm's. I feel like his day is wildly impressive by comparison to mine. But all the same, I am.
Depending on how you look at it. Yeah.
Well, I am a student of Norm more than I sometimes admit, but I'm not shy about that. I think that, I'm watching my world collide with the demands of his. And I think that provided the basis for his and my relationship that all the viewers get to experience now.
My lord, my primary practice area is in criminal defense and civil rights, and in particular, free speech related cases. I practice in state and federal courts. I have cases pending at every level of the federal court system. Appellate courts, a case pending before the U.S. Supreme Court. Getting ready to go there again, or try to go there again on another case. And I represent people accused of all sorts of crimes, including, murder, bank robbery, this, that, and the other thing. In recent years, I've stumbled into a lot of political cases, or what I'll call state trials, cases involving challenges to public authority. And that is where my heart is, and my preference would be to become more involved in these cases as time goes by. But we'll talk more about this in future episodes. We're 43 or 44 minutes in, but the switching of computers has resolved our connectivity issues, and I got the memo, Mike. So We'll be back tomorrow morning.
Absolutely. Yeah. Uncle Pat says, thanks. Still want to hang out with Norm. Maybe one day, I don't think that's as unreasonable as one might.
We'll find a scaffold somewhere with a couple nooses, and I'm sure there'll be people that will be willing to let us hang out together.
Oh, man. Okay. Well, week 2 of Law and Legitimacy.
Yeah.
It begins tonight on Thursday Night Football. So for those about to take their L this week, we salute you. And we will be back tomorrow at 8 a.m. Eastern. Like I said, at LawPod Daily on X. Subscribe to us on Rumble and on YouTube. And if you don't catch us by video or otherwise prefer the audio only, every day's podcast is uploaded to Spotify, Apple Podcasts, Google, Overcast, wherever you find podcasts, we're there. While you're there, leave us 5 stars, leave us a nice review. We do like reading those.
Or leave us alone.
If you don't have anything nice to say, just leave us alone.
But to you haters out there, now you can continue to do it. We don't mind occupying the space in your head that we do. Just don't expect us to acknowledge it with rent payments. It ain't happening.
Don McNeil says, go Eagles. I would say go Panthers, but we're looking putrid. So anyway, on that note, Norm, thank you for opening up. I think that this is the definitive analysis, at least from a legal perspective, of the Shroyer saga, and it's not over. So we'll keep everything in line as you guys take that to the next level. We'll talk tomorrow. I think we've got some more on New Mexico now that there has been a court ruling in that case. The AG
Things are happening in New Mexico. I mean, there's a coup d'etat going on, an internal coup. The governor of New Mexico has decided your Bill of Rights is in her back pocket. My attitude is sit on it, babe, and let's see if the courts require her to do so.
See you tomorrow, Norm.
All right, ciao.
Thank you, everyone.